SwayamPrabha. Digital India. Educated India.
Hello students and welcome to SwayamPrabha. We are doing a 20 hours course on Procedural Law on Crimes, Bharatiya Nagarik Suraksha Sanhita 2023. I am Professor Vageshwari Deswal and I, along with Dr. Saurabh Rana from Faculty of Law, University of Delhi, will be delivering this course. In chapter 1, we discussed an overview of the Bharatiya Nagarik Suraksha Sanhita, how the law has changed from the old CRPC to the new BNSS, what was the necessity for that change, what is the objective of this new law, and we also discussed some of the important definitions. Today, in lesson 2, we will further continue from where we had left in the first lesson, and that is definitions. Along with that, we will also talk about the different functionaries and the different stakeholders under the law. So, first let us talk about the definition of the term inquiry. So, what do you understand by the term inquiry? The law defines it under section 2 clause K as any inquiry other than a trial conducted under this Sanhita by a magistrate or a court. So, first thing is it should be an inquiry, it should not amount to a trial. See, inquiry can be conducted independently and sometimes it can be a part of a trial. But inquiry and trial are two different things. Trial is the judicial proceeding that eventually leads to either the conviction or the acquittal. Inquiry can be a part of the trial, but it is not to be equated with trial. So, inquiry means every inquiry, but it is not a trial, and inquiry is conducted under the Sanhita by a magistrate or court. So, inquiry, when we are talking about this term under BNSS, it is an inquiry which is a judicial proceeding. So, it has to be necessarily conducted by either a magistrate or by a court, and it is different from a trial. Coming to investigation. So, section 2 L defines investigation as all other proceedings under this Sanhita for the collection of evidence conducted by a police officer or by any person other than a magistrate who is authorized by a magistrate in this behalf. So, you see, investigation is police function. Investigation is done. What is the objective of investigation? Collection of evidence. And it is conducted either by a police officer or by any other person. It is not to be conducted by a magistrate. While inquiries are to be conducted by magistrates, investigation is to be conducted by police, and it has to be either by the police or by any other person who is authorized in this behalf. Now, there is an explanation appended to this which clarifies where any of the provisions of a special act are inconsistent with the provisions of the Sanhita, the provisions of the special act shall prevail. Next is section 2M that defines judicial proceeding. And what is judicial proceeding? It includes any proceeding in the course of which evidence is or may be legally taken on oath. So, during judicial proceedings, oath is to be administered, and on that oath a person is required to testify. So, in judicial proceeding, it could be other things also. Along with that, any proceeding in the course of which evidence is or may be legally taken on oath, now that is deemed to be a judicial proceeding. What does that mean? It is only a judicial officer who is qualified to administer oath and take evidence after administering oath. See, once oath has been administered, and if a person lies after taking oath, then that amounts to perjury, which is a punishable offence under the law. Then the next definition is of the term jurisdiction. See, jurisdictional issues are extremely important when we talk about the criminal law system, because in every place, what is the jurisdiction of a police officer? What is the jurisdiction of the magistrate who is competent to try that offence? So, there is a local jurisdiction when we talk about the police. There is a local jurisdiction as well as a pecuniary jurisdiction when we talk about courts, jurisdiction of courts. So, local jurisdiction, that is when we are talking about the territorial jurisdiction in relation to a court or magistrate, means the local area within which the court or magistrate may exercise all or any of his powers under this Sanhita, and such local area may comprise the whole of the state or any part of the state as the state government may by notification specify. So, it is the responsibility of the state government to notify the jurisdiction. That is, what would be the jurisdiction of any particular magistrate, any particular court, any particular police officer also, all that is to be notified by the state, and it has to decide. Sometimes there might be different criteria that might be utilized by the state in determining the local jurisdiction. Sometimes it could be the area that is to be covered. Sometimes it could be the number of people who are residing in an area that are to be covered. So, there are like the demographics, the geography, there are so many considerations while determining the jurisdiction, local jurisdiction, and that is why this is a task which has been entrusted to the respective states. Next definition is that of non-cognizable offence. Section 2(o), it defines what is a non-cognizable offence. So, in the previous lecture, we talked about what are cognizable offences. So, cognizable offences are usually offences of a serious nature in which police has the power to arrest even without obtaining a warrant from the magistrate. Now, what is a non-cognizable offence? How does the law define it? It says non-cognizable offence means an offence for which, and non-cognizable case means a case in which a police officer has no authority to arrest without a warrant. So, if a person has been accused of, or if a person is suspected of commission of a non-cognizable offence, then in such cases, till the time the police officer does not obtain a warrant from the magistrate, they cannot conduct an arrest. Okay. This has been done in order to safeguard the rights of the accused persons, rights of suspected persons. Again, how do we determine whether an offence is cognizable or non-cognizable in nature? Okay. Ordinarily, we apply the test of the punishment of 3 years, but then that is not a hard and fast rule. So, how do we determine whether an offence is non-cognizable in nature? We have to refer to Schedule 1 of the CRPC, now the BNSS, in which the entire list has been laid down, categorizing offences into bailable or non-bailable, cognizable or non-cognizable. Next is the definition of the term notification. Under section 2, clause P, notification means a notification that is published in the official gazette. So, once you prepare a notification and thereafter the moment it is published in the official gazette, it becomes a notification. Section 2(q), offence means any act or omission made punishable by any law for the time being in force. See, the term offence has been defined broadly. It includes act, it includes omission. Illegal act, that is when you do something that you have been forbidden from doing under the law, that amounts to an illegal act. So, when you do an act which is punishable by the law for the time being in force, that is an offence. Similarly, an omission which is punishable, that is, it is an illegal omission. When you don't do something that you are legally supposed to do under the law, that is an illegal omission. So, what is an offence? Any act or omission which has been made punishable by any law for the time being in force, and that includes any act in respect of which a complaint may be made under section 20 of the Cattle Trespass Act of 1871. Next is the definition of the term officer in charge of a police station. So, what does the law say? Officer in charge of a police station includes when the officer in charge of the police station is absent from the station house or unable from illness or any other cause to perform his duties, the police officer present at the station house who is next in rank to such officer and is above the rank of constable, or when the state government so directs, any other police officer so present. So, it is a very simple definition. Either the state government directs that when the officer in charge is not present, then who would be the officer in charge in his place? Otherwise, what would happen? Whosoever is next in rank to that officer in charge and at the same time is also present at the police station. See, someone who is next in rank and that person is not also present, similarly as the police officer in charge is also not present, then the next officer in charge, then the next officer who is present in the police station would be the officer in charge. But then the law has also clarified that a police officer, in order to be designated as an in charge of a police station, must be a police officer who is above the rank of a constable. Next is definition of the term place. Again, it is a broad definition, it is an inclusive definition, because the law under section 2S defines place to include a house, a building, a tent, a vehicle, a vessel. So, any place where we are storing property, any place where people might be staying permanently, temporarily, it could be a house, it could be a building, it could be a tent, it could be a vehicle, it could be a vessel. Here we are referring to ships. So, it could be any of these that would be included within the definition of the term place, and when we use the term inclusive, it means that there could be other places also which could be designated herein. Section 2T, police report. It means a report forwarded by the police officer to a magistrate under subsection 3 of section 193. See what happens whenever the police are given an information as to the commission of the crime. That sets the criminal justice machinery in motion. Immediately they start investigations. They try to contact as many number of witnesses as they can. They try to collect evidences, whatever are available. They try to question the suspect. They, if required, they also try to arrest the accused person. And then they have to prepare a comprehensive report. Ever since the time they received the information, what all steps have been taken by them to apprehend the criminal, to detect the truth in the information and to bring the accused to book. So, what all steps were taken by you? They have to prepare a comprehensive report. In case the accused was to be medically examined, in case the victim was to be examined. So, reports of all those examinations, in case the statements were to be recorded by a magistrate. So, all that and more, whatever they did in order to establish the guilt of the accused person, all the material that they collected in relation to that information that they got regarding the crime, all that has to be submitted to the court in order that the court may further take cognizance of the same, frame charges and thereupon start trial in case there is merit in the accusations. So, the entire report that is prepared by the police during investigation and when it is submitted to the magistrate, this is known as police report. Section 2, clause U. What is police station? Under the law, police station means any post or place declared generally or specially by the state government to be a police station, and it includes any local area specified by the state government in this behalf. Then section 2 clause V, public prosecutor. So, public prosecutor means any person appointed under section 18 and includes any person acting under the directions of a public prosecutor. So, you see this is also a broad term, one who is appointed under section 18 and any person who is acting under the person so appointed under section 18, they would all be covered within the definition of the term public prosecutor. Thereafter, what do you understand by the term subdivision? Section 2 clause W defines subdivision to mean a subdivision of a district. Then summons case. See, whenever we talk about summons cases and warrant cases, the definition is very simple. Summons cases are those in which the punishment that has been prescribed under the substantive law is for a term which is less than 2 years, and whenever the prescribed imprisonment for a term is for a term more than 2 years, then that is a warrant case. It is a very simplistic definition. What does the law say? Section 2 clause X, summons case means a case relating to an offence not being a warrant case. So, summons cases are different, warrant cases are different, and what is warrant case? Section 2Z defines warrant case to mean a case relating to an offence punishable with death, imprisonment for life, or imprisonment for a term exceeding 2 years. So, when we have a simple definition that a summons case is a case which is not a warrant case, and a warrant case in which the punishment has to be necessarily above 2 years, it could be 2 years, 3 years, 7 years, life imprisonment, death, it could be any term of imprisonment. But if it is less than 2 years, then it would be a summons case. If it is more than 2 years, the prescribed punishment, then it would be a warrant case. And then one more definition, section 2 clause Y. Who is a victim? So, victim means a person who has suffered any loss or injury caused by reason of the act or omission of the accused person and includes the guardian or legal heir of such victim. So, I am a victim if somebody was supposed to fulfill any obligation towards me, but the person did not do that. So, that is a legal omission. So, for an illegal omission of that person, I could be victim. For an illegal act committed by that person, I could be a victim. So, who can be a victim? Anyone against whom either an illegal act or an illegal omission has been done and that has resulted into any kind of a loss or injury. See, when we talk about injury in the realm of criminal law, the injury can be to the victim in terms of mind, body, reputation or property. So, it could be any kind of an injury. So, what is required is that the victim who has suffered because of that illegal act or illegal omission, there should be either a loss or there should be some kind of an injury, and it would also include the guardian, it would also include the legal heirs. Suppose the person who has suffered the injuries, the one who has been victimized is a person suffering from unsoundness of mind or is a person who is a minor, then in such persons the guardian of that person would also be deemed to be the victim. There might be the cases where the victim comes to his injuries, where the person dies. So, in such cases the legal heirs of that victim would be entitled to all the relief that would be given to the victim. So, this is something which clarifies the fact that in certain categories, crimes they do not abate even on the death of the accused person, the death of the victim. If the accused has done an act and the victim dies, the crime does not come to an end therein. There are people who were interested in the well-being of the victim, like the guardian, the heirs. They would also be treated as victims for the purposes of taking decisions, either whether the state can drop prosecution, whether they have to be granted certain compensation. So, whenever we talk about rights of victims, so now victim is a broad term which is not confined to the one who suffers injury on his person. It also includes the guardian of such person. It also includes the legal heirs of such person. Section 2, subclause 2. What does it say? Words and expressions used herein, but not defined. So, we are talking about words and expressions that have been used across the length and breadth of Bharatiya Nagarik Suraksha Sanhita. So, there are so many terms that have been used therein, but they have not been defined expressly under the definition clause, because see, we have only 26 definitions, the number of alphabets A to Z, and that is exactly the number of definitions that we have under the Bharatiya Nagarik Suraksha Sanhita. So, there is a limit to the number of definitions. But then there are so many other terms that have been included in this law. So, what does the law say? So, terms, expressions which have been used herein, but they have been not defined herein, but they have been defined in the Information Technology Act 2000, or they have been defined in the Bharatiya Nyaya Sanhita. So, the meaning of those terms shall be the same as has been given under either the Bharatiya Nyaya Sanhita or the Information Technology Act. So, whenever there is any term accruing in the BNSS about which you have any sort of a confusion, so what are you supposed to refer to? Either the definitions given under the BNSS, or if the term has been defined under the BNS, or if the term has been defined under the IIT Act, you can refer to those statutes, and the meaning has been that has been given to that term or expression under that specific law would be the same term, would be the same meaning that would be assigned to that term or expression under the BNSS as well. Section 3 talks about construction or interpretation of references. The law says, unless the context otherwise requires, any reference in any law to a magistrate without any qualifying words, magistrate of the first class or a magistrate of the second class shall, in relation to any area, be construed as reference to a judicial magistrate of the first class or judicial magistrate of the second class, as the case may be, exercising jurisdiction in such area, and where under any law other than this Sanhita, the functions exercisable by a magistrate relate to matters which involve the appreciation or shifting of evidence, or the formulation of any decision which exposes any person to any punishment or penalty or detention in custody pending investigation, inquiry or trial, or would have the effect of sending him for trial before any court, they shall, subject to the provisions of this Sanhita, be exercisable by a judicial magistrate. So, here see there is a difference between executive magistrate and judicial magistrate. Anyway, executive magistrate is what is known as an oxymoron, because when we talk about magistrate, we are essentially referring to judicial functions. In our country, we have a separations of powers. There is legislature, executive and judiciary. So, when we are clubbing the powers of the executive and judiciary in one single person, that is the person who is known as an executive magistrate, and that person has those powers for certain specified purposes, and those purposes they have also been specified in the BNSS itself. And then where under any law under other than the Sanhita, the functions exercisable by a magistrate relates to matters. Now, we will talk about clause B, which are administrative or executive in nature, such as the granting of a license, the suspension or cancellation of a license, sanctioning a prosecution or withdrawing from a prosecution. They shall, subject to provisions of clause A, be exercisable by an executive magistrate. Section 4. This talks about trial of offences under BNS 2023 and other laws. So, the main substantive law related to crimes in our country is the Bharatiya Nyaya Sanhita 2023. Earlier it was the Indian Penal Code, now it is BNS. Now, in addition to BNS, we have so many other criminal law statutes. We have the MTP Act, PCPNDT Act, we have the SC/ST Prevention of Atrocities Act, we have the IT Act, and there is POCSO. There are so many other statutes also. So, whenever there has to be any criminal proceeding initiated, whether it is in respect of the main substantive law, which is the BNS 2023, or whether that is in relation to any other criminal law. How is that to be done? Section 4 says all offences under the Bharatiya Nyaya Sanhita 2023 shall be investigated, inquired into, tried and otherwise dealt with according to the provisions hereinafter contained. So, all offences, whether we are talking about investigations, whether we are talking about inquiries, whether we are talking about trials. Now, students, when we have discussed all these definitions so far, so I am sure you would be able to appreciate the difference between investigation, which is essentially a police function, inquiry, which is conducted by magistrates, trials again, which is a judicial function, or which are otherwise dealt with according to the provisions hereinafter contained, and all offences under any other law shall be investigated, inquired into, tried and otherwise dealt with according to the same provisions, but subject to any enactment for the time being in force regulating the manner or place of investigating, inquiring into, trying or otherwise dealing with such offences. So, students, after discussing the definitions, after discussing the preliminaries of the Bharatiya Nagarik Suraksha Sanhita, let us now delve into the next aspect of the law, which is what is the role played by different functionaries under the procedural law. But before that, another important aspect is to understand how to read the provisions of our procedural law. Whenever we talk about BNSS, earlier which was the CRPC, constitutionalization of the law is an absolute must. See, there is a difference between the civil law and criminal law. In criminal law, what is at stake? The liberty of an individual. Okay, the person might be arrested, the person might be put behind bars. In extreme cases, the person might be subjected to death penalty also. So, what is at stake is the right to life and personal liberty, which is guaranteed under Article 21 of the Constitution. So, whenever we read about the criminal procedural law, since the stakes are higher, the entire law has to be read and interpreted and understood subject to the provisions of the Constitution of India, which is the basic law of our country, that is the highest law of the land. So, whenever we talk about the procedural law, let us constitutionalize the same. What are the main constitutional articles that we need to know in order to read the procedural law? One is Article 14 of the Constitution, equality before law, and what does it say? In plain terms, the law declares the state shall not deny to any person equality before the law or equal protection of the laws within the territory of India. In the eyes of law, everybody is equal. We are all subject to equal protection of laws. Then Article 20, protection in respect of conviction of offences. The law says no person shall be convicted of any offence except for violation of a law in force at the time of commission of the act charged as an offence, nor be subjected to a penalty greater than that which might have been inflicted under the law in force at the time of the commission of the offence. So, this is a law against ex post facto law. That is, criminal laws, especially when we talk about, they are always to be prospective in operation, they are never to be applied retrospectively. Then this is the same article that prohibits double jeopardy. What it says? No person shall be prosecuted and punished for the same offence more than once. Third, this is doctrine against self-incrimination. What does it say? No person accused of an offence shall be compelled to be a witness against himself. Okay? You cannot be compelled to testify against yourself. Article 21, protection of life and personal liberty. What does it say? No person shall be deprived of his life or personal liberty except according to procedure established by law. And what is the procedure for trying crimes that has been established by the law? That is the Bharatiya Nagarik Suraksha Sanhita of 2023. So, how do we read it? No person to be deprived of his right to life and personal liberty. Whenever we read any provision of CRPC, we have to be mindful of Article 21. Then Article 22. This talks about protection against arrest and detention in certain cases. It says, no person who is arrested shall be detained in custody without being informed as soon as may be of the grounds for his arrest, nor shall he be denied the right to consult and be defended by a legal practitioner of his choice. So, students, as we will go through the provisions of BNSS, and when we go to the chapter which deals with arrest, you will see that now what has been done, all these provisions, they have expressly found a place under the new Sanhita when we talk about rights of arrested person. Earlier, when we had the procedural law, these were later on thought of by our judiciary. The judiciary issued certain guidelines. In light of those guidelines, then we introduced those protections to rights of accused persons, rights of arrested persons in the CRPC. They were all an afterthought, but now they have been systematically introduced in the Sanhita. Then 22 clause 2, every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours of such arrest, excluding the time necessary for the journey from the place of arrest to the court of the magistrate, and no such person shall be detained in custody beyond the said period without the authority of a magistrate. Then clause 3, nothing in clauses 1 and 2 shall apply to any person who for the time being is an enemy alien, or to any person who is arrested or detained under any law providing for preventive detention. So, certain categories of people, they have been excluded from the protection that is guaranteed under Article 22. Then clause 4, no law providing for preventive detention shall authorize the detention of a person for a period longer than 3 months unless an advisory board consisting of persons who are or have been or are qualified to be appointed as judges of a high court has reported before the expiration of the said period of 3 months that there is in its opinion sufficient cause for such detention. That is, the detention has to be necessarily be in the knowledge of the judiciary, and provided that nothing in the subclause shall authorize the detention of any person beyond the maximum period prescribed by any law made by Parliament under subclause B of clause 7, or such person is detained in accordance with the provisions of any law made by Parliament under subclauses A and B of clause 7 when any person is detained in pursuance of an order made under any law providing for preventive detention. The authority making the order shall, as soon as may be, communicate to such person the grounds on which the order has been made, and shall afford him the earliest opportunity of making a representation against the order. But nothing in clause 5 shall require the authority making any such order as is referred to in that clause to disclose facts which such authority considers to be against the public interest to disclose. So, such information is prohibited from disclosure if the authority feels that, see, we are supposed to disclose certain information, but this is a particular kind of information which would be against the public interest to disclose. Then what the authorities can do? They can withhold such kind of an information from being disclosed. Then clause 7, Parliament may by law prescribe the circumstances under which and the class or classes of cases in which a person may be detained for a period longer than 3 months under any law providing for preventive detention without obtaining the opinion of an advisory board in accordance with the provisions of subclause A of clause 4, the maximum period for which any person may in any class or classes of cases be detained under any law providing for preventive detention, and the procedure to be followed by an advisory board in an inquiry under subclause A of clause 4. So, after talking about the relevant constitutional provisions, let us move on to the next topic, which is functionaries and stakeholders under the code. See, what does the procedural law do? Procedural law lays down the mechanism for enforcement of criminal law. So, how do we enforce the criminal law? We have to record information of a crime where it has been committed. Whenever we receive any information, we have to record the information. After recording the information, we have to proceed to the spot, conduct investigations, if required apprehend the accused persons. We might need to contact witnesses, we might need to collect evidences. Once we submit it to the magistrate, then the magistrates, they are supposed to conduct trials. If the accused is adjudged guilty, the accused is to be sent to the prison where the person will undergo imprisonment. After imprisonment, sometimes we need to take steps for rehabilitating the offender. So, there might be correctional officers also involved. So, all these people, they are known as the functionaries. All the people who perform these functions under the criminal justice system are known as functionaries under the criminal justice system. So, who are the functionaries? Those who perform various functions from investigation to adjudication and sometimes even beyond adjudication, like police, prosecution, defense lawyer, court, judicial officers, executive magistrates. Additionally, some functions are performed under criminal justice system by prison authorities, correctional services personnel. So, all these people, they are performing different functions under the code, and that is why they are known as functionaries under the code. Then there are some people who are not performing any function under the code, but they are significant stakeholders because they have stakes in the criminal justice system. They want justice to be delivered. And who are those people? One is the victim, a person against whom an offence has taken place. The law forbids commission of crime, still a person has committed a crime and there is someone who has been victimized by the commission of that crime. Now, the victim is an important stakeholder. He wants to ensure that one who has committed the crime should be punished by the state. So, victim holds important stakes, and the rights of the victims, once a crime has been committed, but throughout the investigation, thereafter throughout the trial and all, we have to protect and keep in mind the interests of the victim, because a victim is an important stakeholder. Next would be the accused. See, the accused should not be punished unless and until he has actually committed a crime. So, if he is an innocent person but accused of a crime, he should not be punished. If at all he is punished, he should be punished only for what he has done. He should not be punished disproportionately. So, in that sense, the accused also has important stakes in the criminal justice system. Then there is the state, because eventually who is the authority who has laid down the laws? It is the state. People, they have given away their rights to the state. We do not take the law in our own hands. It is the state who is the protector, who is the guarantor of my rights, and it is the state that will protect my person against any kind of harm to my person or my property. In turn, what am I supposed to do? I am supposed to abide by the laws that have been laid down by the state. I am supposed to respect those laws. So, the most important stakeholder is the state. The state has to ensure that people, they abide by the law so that there can be peace in the society. If somebody violates the laws that have been laid down by the state and the person can get away with such violation, there would be a very wrong signal going to the rest of the people. People would feel cheated that, see, we are trusting the state. We do not take force in our own hands, but the state has not been able to protect me, and once, even if a crime was committed, the state has not been able to do justice to me. So, that is why state is the most important stakeholder, and obviously there is the general public. We need to be confident that there is a state administered machinery that is taking care of our rights. that is protecting us. There is a police out there that is going to prevent the commission of any crimes. In case a crime has taken place, there is the state machinery, there is police, there is courts, there are so many authorities who would be taking care, who would be taking steps to ensure that the guilty is brought to book and that I am not again subjected to those crimes. So, one who has committed an offence should be punished and those who are innocent should not be punished. So, that is the general public who are equally important stakeholders in the criminal justice system. Now, let us discuss the role of these functionaries in detail. The first functionary under the criminal justice system is police force. Who is the police? They are persons, policemen, and police is also a force as an institution. So, persons or a force that are employed with the responsibility to detect and to prevent crime. See, their responsibility does not arise when a crime has already been taken place. They have been employed in order to prevent crimes, in order to detect crimes, and in case crimes have taken place, so then they are supposed to investigate into those crimes and ensure that the accused is brought to book. We have different laws relating to police. The main is Police Act of 1861. Then there are state laws that have replaced this act. For example, Delhi has its Police Act of 1878, Bombay has its Police Act of 1951. Then there is the Home Secretary who assists the MHA in supervising, exercising control and taking all decisions regarding administration of police. So, in states, overall administration of state police force is looked after by the DGP. The Director General of Police is in charge of the overall administration of state police force. And thereafter, what is the hierarchy? After the DGP, there is this Additional Director General of Police, then there is the Inspector General of Police, then there is the Deputy Inspector General of Police, Senior Superintendent of Police, SP, Additional SP, Assistant SP, DSP, Inspector, Sub-Inspector, Assistant Sub-Inspector, Head Constable, Police Nayak, Police Constable. So, this is the entire hierarchy of police officials designated to ensure peace and security of citizens. The second category of functionaries is prosecutors. See, crimes are public offences, they are committed against the state and therefore, prosecution is always initiated by the state. The state has laid down certain laws. If anybody violates those laws, so the accused has committed an offence against the state. The nature of the crime might be private, still it is known as a public offence, because a crime has the capacity to creating an alarm and scare in the society. That is why crimes, they are known as public wrongs. So, irrespective of the one who is harmed, prosecution is always initiated by the state. Prosecutors. Now, who are prosecutors? Those who conduct prosecutions. Prosecutors are officers who are appointed by the central and state governments. And what do prosecutors do? They conduct criminal proceedings on behalf of state in different courts. See, in cases that are instituted on police report, prosecution is always conducted by the assistant public prosecutor. In private complaints, prosecution is conducted by complainant or by his authorized counsel. So, what is the responsibility or the duty of prosecutor? As I said, prosecutor is an officer of the court. So, what is the prosecutor supposed to do? Prosecutor is not supposed to ensure that the accused is convicted. No, that is not his responsibility. The responsibility of the prosecutor is to place evidence before the courts, to help the court in arriving at a correct conclusion, to help in administering justice. So, what is the duty of prosecutor? To place evidence before the court. Second, to assist in decision making. So, again I report, prosecutor is not supposed to ensure that the accused is convicted. What if the accused was innocent? Suppose he was not guilty, you are not going to push for his conviction when he is not guilty. What you are supposed to do is place the entire material on record before the court. assist the court in coming at a right decision and ensure that justice is done. Who are public prosecutors? Section 18 of the BNSS defines public prosecutors. It says, for every high court, the central government or the state government shall, after consultation with the high court, appoint a public prosecutor and may also appoint one or more additional public prosecutors for conducting in such court any prosecution, appeal or other proceeding on behalf of the central government or the state government as the case may be, provided that for National Capital Territory of Delhi, the central government shall, after consultation with the High Court of Delhi, appoint the public prosecutor or additional public prosecutors for the purposes of this subsection. The central government may appoint one or more public prosecutors for the purpose of conducting any case in any district or local area. For every district, the state government shall appoint a public prosecutor and may also appoint one or more additional public prosecutors for the district, provided that the public prosecutor or additional public prosecutor appointed for one district may be appointed also to be a public prosecutor or an additional public prosecutor as the case may be for another district. The district magistrate shall, in consultation with the sessions judge, prepare a panel of names of persons who are, in his opinion, fit to be appointed as public prosecutors or additional public prosecutors for the district. Clause 5. No person shall be appointed by the state government as the public prosecutor or additional public prosecutor for the district unless his name appears in the panel of names prepared by the district magistrate under subsection 4, and notwithstanding anything in subsection 5 where in a state there exists a regular cadre of prosecuting officers, the state government shall appoint a public prosecutor or an additional public prosecutor only from among the persons constituting such cadre, provided that where in the opinion of the state government no suitable person is available in such cadre for such appointment, that government may appoint a person as public prosecutor or additional public prosecutor as the case may be from the panel of names prepared by the district magistrate under subsection 4. Now, for the purpose of this subsection, regular cadre of prosecuting officers means a cadre of prosecuting officers which includes therein the post of public prosecutor by whatever name called and which provides for promotion of APP by whatever name called to that post. Prosecuting officer means a person by whatever name called appointed to perform the functions of a public prosecutor, special public prosecutor, additional public prosecutor or assistant public prosecutor under this Sanhita. A person shall be eligible to be appointed as a public prosecutor or an additional public prosecutor under subsection 1 or subsection 2 or subsection 3 or subsection 6 only if he has been in practice as an advocate for not less than 7 years. So, this is a mandatory requirement, minimum 7 years of practice after being enrolled as a lawyer. It is only when you have been in active practice as an advocate for minimum 7 years that a person is eligible to be appointed as a PP or an APP. The central government or the state government may appoint for the purposes of any case or class or cases a person who has been in practice for an advocate for not less than 10 years as a special public prosecutor. See, sometimes what happens to present cases before a POCSO court, to fight rape cases, there is an additional requirement that there should be a person who has a minimum 10 years of practice or so. So, in such cases, such senior people, they are to be appointed as special public prosecutors, provided that the court may permit the victim to engage an advocate of his choice to assist the prosecution under this subsection. So, you see, even where they get a permission to engage a lawyer of their own choice, prosecution is mainly conducted by the prosecutor, but where the court has permitted you to engage an additional lawyer, the additional lawyer can also argue before the courts. For purposes of subsection 7 and subsection 8, the period during which a person has been in practice as an advocate or has rendered, whether before or after the commencement of this Sanhita, service as a public prosecutor or as an additional public prosecutor or assistant public prosecutor or other prosecuting officer by whatever name called, shall be deemed to be the period during which such person has been in practice as an advocate. Section 19. Who are assistant public prosecutors? The law says the state government shall appoint in every district one or more assistant public prosecutors for conducting prosecutions in the court of magistrates, and the central government may appoint one or more assistant public prosecutors for the purpose of conducting any case or class of cases in the court of magistrates. Clause 3. Without prejudice to provisions contained in subsections 1 and 2, where no assistant public prosecutor is available for the purposes of any particular case, the district magistrate may appoint any other person to be the assistant public prosecutor in charge of that case after giving notice of 14 days to the state government, provided that no police officer shall be eligible to be appointed as an assistant public prosecutor if he has taken any part in the investigation into the offence with respect to which the accused is being prosecuted, or where the police officer is below the rank of an inspector, then he shall not be allowed to be appointed as an assistant public prosecutor in that case. Section 20 deals with Directorate of Prosecution. So, students, there have been many changes in this provision, and the changes that have been introduced in the BNSS, as you will see the screen, those changes they have been highlighted in red ink. So, the state government may establish a Directorate of Prosecution in the state consisting of a Director of Prosecution and as many Deputy Directors of Prosecution as it thinks fit, and a District Directorate of Prosecution in every district consisting of as many Deputy Directors and Assistant Directors of Prosecution as it thinks fit. A person shall be eligible to be appointed as a Director of Prosecution or a Deputy Director of Prosecution if he has been in practice as an advocate for not less than 15 years or is or has been a sessions judge, or as an Assistant Directorate of Prosecution if he has been in practice as an advocate for not less than 7 years or has been a magistrate of the first class. Now, the powers and functions of the Director of Prosecution shall be to monitor cases in which offences are punishable for 10 years or more, or with life imprisonment or with death, to expedite the proceedings and to give opinion of filing of appeals. The powers and functions of Deputy Director of Prosecution shall be to examine and scrutinize police report and monitor the cases in which offences are punishable for 7 years or more, but not less than 10 years, for ensuring their expeditious disposal. The functions of the Assistant Director of Prosecution shall be to monitor cases in which offences are punishable for less than 7 years. Notwithstanding anything contained in subsection 7, 8 and 9, the Director, Deputy Director or Assistant Director of Prosecution shall have the power to deal with and be responsible for all proceedings under this Sanhita. The other functions and power. So, here they have used the term other. This is a new addition to the law. The other powers and functions of the Director of Prosecution, Deputy Directors of Prosecution and Assistant Directors of Prosecution, and the areas for which each of the deputy directors of prosecution or assistant directors of prosecution have been appointed shall be such as the state government may by notification specify. The provisions of this section shall not apply to the Advocate General for the state while performing the functions of a public prosecutor. Section 338 deals with appearance by public prosecutor. What it says? The PP or APP in charge of a case may appear and plead without any written authority before any court in which that case is under inquiry, trial or appeal, because they are in charge of the case. So, wherever the case is being tried, they do not need any authorization in this regard. See, after the BNS, the scope and ambit, the powers of prosecutors that have been expanded, and now they have to be continuously in touch with the police while the investigations are being conducted. So, with their inputs also, the police has to conduct better investigations, and while with their involvement in the case during the stage of investigation, they are better armed to argue the cases before the courts. Subsection 2. If in any case any private person instructs his advocate to prosecute any person in any court, the public prosecutor or APP in charge of the case shall conduct the prosecution, and the advocate so instructed shall act therein under the directions of the PP or APP, and may, with the permission of the court, submit written arguments after the evidence is closed in the case. Under section 339, which talks about permission to conduct prosecution, any magistrate inquiring into or trying a case may permit the prosecution to be conducted by any person other than a police officer below the rank of inspector, but no person other than the Advocate General or government advocate or a public prosecutor or assistant public prosecutor shall be entitled to do so without such permission, provided that no police officer shall be permitted to conduct the prosecution if he has taken part in the investigation into the offence with respect to which the accused is being prosecuted, and any person who is conducting the prosecution may do so either personally or can do so by an advocate. So, students, in this session we talked about the various functionaries and the various stakeholders under this code. In addition to some of the definitions we discussed, such as what is a summons case, what is a warrant case, what is a cognizable case, what is a non-cognizable offence. So, we discussed all that. Then we proceeded to discuss who are the various functionaries under the code upon whose shoulders lies the responsibility of ensuring that the functions that have been laid down under this code, they are sufficiently fulfilled. So, towards this end, foremost is the police, entire investigation that is to be conducted by the police. Next, after the police conducts its investigation, submits its police report before the court, next comes the role of prosecutors. Prosecutors, they fight the case on behalf of the state. In criminal cases, what happens? The prosecution is always to be conducted by the state, and for that purpose the state appoints certain officers of the court who are named as public prosecutors. So, those prosecutors, they fight the case on behalf of the state. Then there is the defense counsel. So, on one side there is the prosecutor who fights on behalf of the state because prosecution is initiated by the state. On the other hand, there is a defense lawyer. Whether it is a prosecutor, whether it is a defense lawyer, they are both officers of the court. It is the function of the lawyers to present all the material before the court and help the court in coming to a correct decision, so that injustice is not done in any case. So, prosecutors, they have lot of powers. They are also supposed to assist the police while conducting the investigations, and thereafter assist the courts while they are arriving at the decisions. Then we have defense lawyers, and then we have finally the courts that conduct the trial, and then they award the decision in accordance with the settled and established principles of law that have been laid down in the BNSS. Now, in addition to those functionaries, we also have the prison authorities, we also have the correctional services personnel. See, like when we talk about offenders under the Juvenile Justice Act, when we talk about the Boston Schools Act. Now, when we talk about juvenile offenders, rehabilitation is a very integral part. Even otherwise, see, when we talk about adult offenders also, whether they are to be released on probation, whether they are to be released on parole, how all that is to be done, and for that purpose we have these prison officials, we have these correctional services personnel in place who have all been appointed, duties and responsibilities that have been laid down by the law, well defined duties and responsibilities have been laid down. In addition to that, there are the stakeholders. Stakeholders are the state. Stakeholders are the general public. Another stakeholder is the victim, and of course, a stakeholder is the accused. So, students, after this lesson, I hope now you are very clear about who are the important functionaries and stakeholders in our criminal justice system. That will be all. Thank you.